Hello, my name's Douglas Guilfoyle, and in this short presentation I'd like to introduce the foundational concepts in our international criminal law course. So, here we have an image of the Chief Prosecutor at the Nuremberg tribunals, Justice Robert H. Jackson. And Nuremberg is still generally seen as the beginnings of modern international criminal law. But we won't be starting today with that history. We'll be taking one step back and looking at three key topics. So we're going to be talking about the sources of international criminal law. Where did the law that prosecutors like Jackson at Nuremberg or Prosecutor Bensouda at the International Criminal Court, where does that law come from? Then we're also going to be putting this in the context of state jurisdiction. If international criminal law is going to be effective, most prosecutions will ultimately have to occur at a national level. And more than that, when we look at the International Criminal Court and terrorism suppression conventions, those frameworks draw upon principles of national jurisdiction. That is, the parties to the International Criminal Court have delegated certain jurisdiction to it, so they can only give it jurisdiction that they themselves possess and can give some or all of that jurisdiction. So before looking at certain treaty-based international courts, it's important to understand what nation-states themselves can do in terms of both the power they can give to international courts and tribunals, but also what they can do without them. And then briefly we're going to be looking at the question of what are the purposes of international criminal law? It's very hard to tell whether an institution or a set of institutions like international criminal law is doing a good or bad job if we don't know what we think it is there to do in the first place. So let's turn to the first of our questions, the sources of international criminal law. And here we have an image of the newly completed International Criminal Court building in The Hague. So where does the law it applies come from? Well, the sources of international criminal law is itself a somewhat complex idea. I mean, first we have to understand what we mean by a doctrine of sources. So the idea of a doctrine of sources is, it is the body of law which tells you which rules have the force of law. So it is the rules that enable you to identify the rules. In the jurisprudence of HLA Hart, this is called the rule of recognition, the rule that tells us which other rules have the force of law. And when we come to think about where international criminal law comes from, there are a number of relevant legal concepts. First, we have to give some thought to the question of how international law is different from national law. Now, obviously, one of the key differences of international law is that it lacks a central legislature, a central court system, central political processes, and centralized enforcement. We have rough approximations to some of these things in, say, the General Assembly of the United Nations, which looks like a legislative body but does not have the power to enact binding law. And we have something that begins to look a bit like enforcement mechanisms in the International Criminal Court. But the truth is actually much more complex. What we really have here is a system of rules for coordinating cooperation and imposing certain fundamental limits on legally equal sovereign states, which means a number of things. If states are the source of law, and if states are the fundamental unit of the international legal system, then as a formal matter, no state can enjoy any greater legal power than any other. And the rights and powers of a state can only be as it were, large or expansive as is consistent with every other state having the same rights and legal powers. That doesn't mean that there aren't differences in real-world power between states. Obviously there are. But there are differences between legal persons, be they individuals or corporations, in a national legal system. But the other thing that flows from states as the origin point of international law is that the great majority of international law is consent-based. That is, a rule is binding on a state principally because it has consented to it. There are some exceptions which we'll touch upon, but that consent-based limitation has a flip side, which is the rule that third parties are not bound by the rules of a treaty which they have not ratified, sometimes known as the pacta tertiis rule, the idea that certain rules of international law can't bind non-parties or generate legal effects for them. Now, you might then question, well, is this really law at all? If it's just sort of the rules of a club of sovereign states, why would we call it law? Well, to some extent, it doesn't matter whether we call it law or not. It is rule-based, and it is something we can study as part of the field of law or politics. But if the only thing that counts as law is something which is directly enforced by, as it were, a police force, then very substantial areas of law aren't law either. So in a national context, administrative law or constitutional law has really no direct enforcement mechanisms. It works only because the government agrees to abide by it, that it's fundamental to its legitimacy that it does so. And also systems of indigenous or tribal law throughout the world frequently function without centralised, as it were, police forces, court systems, and so forth. There is a decentralised order where the community itself, as it were, polices the boundaries of law. So there are versions of legal systems that look not too dissimilar in some respects from international law. And the challenge of international law is that it's both at the one level made up with, compared to a national system, it would seem some fairly broad and basic rules and a very limited number of rule makers. But at the other hand, in some areas, such as trade law and increasingly international criminal law, it has reached a great depth of complexity. So you have this system that pulls in different directions. And the idea of a system that pulls in different directions is common to a number of things we'll be studying. But fundamentally, much of the international criminal law we look at will be embodied in treaty law, whether it's the treaty form of the Geneva Conventions of 1949 or the Rome Statute of the International Criminal Court. We'll find that treaties are very important. Now that's helpful because treaty law is at least written down. So you have the ability to have a debate about what rules mean, starting from a common text. But as I've said, one of the limitations of treaty law is it is binding only upon the parties to it, because treaties, like contract, are given legal force by the consent of the parties. A major alternative source of law in the international legal system is customary international law. Now, one might think of this as similar perhaps to the common law of Commonwealth countries, or some forms of unwritten traditional law or knowledge. But the idea of customary international law is it is rules that have arisen through the consistent custom and practice of states over time, so this is known as state practice, but where there is evidence that states regard these rules as legally binding, not merely convenient or courteous. And that second element, the belief in legal bindingness, is often referred to by the Latin opinio juris, as it were, a view that this is law. That gives rise to a number of theoretical questions, which I won't go into now, but it's enough to note that you have an unwritten source of law, which is evidenced by elements of state practice, and then evidence that states believe the rule to be binding. Now, treaty and customary international law can interact. So the idea of a war crime long predated Common Article 3 of the Geneva Conventions, which specified that certain offences in war should be punished. So one could say, well, a treaty provision like Common Article 3 of the Geneva Conventions, or perhaps certain provisions of the Rome Statute of the International Criminal Court, represent a written codification of a pre-existing customary rule. But conversely, one could say, well, if certain rules that begin in writing and are acknowledged only by a limited number of states come to be respected by other states, then a rule that starts as a treaty norm might become part of customary international law as well. So we have this interaction between treaty and customary international law. And when we look at something like the Rome Statute, there are some provisions which we could say are codifications of previous customary international law, and there are some that are new rules of treaty law. And the question then becomes, well, if widely enough accepted, could the Rome Statute play a role in changing customary law as well? Now, why does that matter? Well, customary international law is said to be generally binding upon all states. So it emerges from consistent state practice and opinio juris, and then binds the entire international community, unless a state persistently objects, demonstrates its, as it were, non-consent to the rule over time. So, in a sense, consent in customary international law is presumed, and the notion of consent as underpinning international law is upheld by the option of being a continuous objector to a rule. Now, whether that really works in some areas of international criminal law, the idea of a persistent objector, is an interesting idea we may come back to. And so, finally, there's a role for what are called general principles of law. So, generally speaking, an international criminal court or tribunal will apply, in the first instance, rules of its own statute, which may be embodied in a treaty. Then it might look to other treaty-based rules. Then it may look to customary international law. And finally, as a kind of gap filler, you have this idea that you might turn to general principles of law. And in some cases, you may need to look to general principles of law to provide more detail such that you can successfully run a criminal trial as to the nature or content of an offence. So, for example, one might say that the concept of outrages upon personal dignity found in Common Article 3 of the Geneva Conventions includes sexual offences. But then how do we define the content of those offences? Well, one might have to look to general principles of law common to major legal systems to distill a definition that can give content to those provisions in the absence of any more certain source one can look to. And to some extent that was the approach taken by the International Criminal Tribunal for the former Yugoslavia, though the International Criminal Court itself has much more clearly defined offences against the person and sexual offences in its statute. Finally, we should note the concept of jus cogens norms or rules. This is the idea that international law contains certain principles or higher order rules or norms from which no derogation is possible. The essential idea here is of a rule or norm which can trump other rules. So one might say, for example, that genocide is not merely a rule of international law, it's a jus cogens rule. Therefore, for example, any treaty that one might attempt to enter to commit genocide, where the substance of the agreement is the extermination of another ethnic, national, racial or religious group, that would per se be illegal. That's fine if we think we actually need a rule to tell us that genocide is illegal. The more difficult question comes into how a jus cogens norm in effect will trump other norms. So a long-standing principle of international law is, for example, the immunity of heads of state. So if a head of state is accused of genocide, do they retain their immunity from arrest and prosecution while in office? Or does the nature of the jus cogens norm strip them of their immunity? And there are different views as to how that question should be resolved. The key thing to note about jus cogens is that different writers will define it, or define the rules that fall within it, more broadly or more narrowly. So at one extreme, some writers have contended that the entire body of human rights law is jus cogens. Now that would actually make the rules of human rights law quite difficult to apply, because frequently they have to be balanced against other rules, including other human rights. So how would that be possible if every norm was at this supreme level? The more narrow view would say that jus cogens embodies only certain, typically criminal rules of international law, such as genocide, war crimes, crimes against humanity, slavery, torture, and apartheid. And one might add or subtract a number of offences at the edge of that boundary. But it's an important concept that we will come back to. Now, in dealing with international criminal law, then, we are going to have some sense of where these norms of international criminal law come from. And that's, in essence, what I've attempted to outline here. So let's just revise a number of key principles then. So I've spoken to some extent about the critical nature of treaties to the development of international criminal law. And indeed, modern international criminal law has largely progressed in some senses through treaties. So the statute of the Nuremberg International Criminal Tribunal was a treaty. The Geneva Conventions of 1949 were treaties. The statute of the International Criminal Court is a treaty. The Genocide Convention is a treaty. However, there are other instruments that are important as well. The statutes of the Tribunal for the former Yugoslavia and the Tribunal for Rwanda were both embodied in Security Council resolutions. But again, the Security Council derives its authority from the Charter of the United Nations, which is itself a treaty. So treaties are an important source of law. So one of our questions as lawyers will be, how do we interpret those treaties? And Articles 31 and 32 of the Vienna Convention on the Law of Treaties lay out the basic principles of interpretation. And Article 31 tells us that treaties are to be, or that the terms of treaties are to be interpreted to be given their ordinary meaning in context, but in light of the object and purpose of the treaty as a whole. Now that's an interesting approach because it embodies what are normally seen as two different schools of interpretation of a text: a literal or ordinary meaning interpretation and a teleological or object and purpose interpretation. So the law of treaties, perhaps somewhat unhelpfully, tells us that you can look at both. Article 32 of the Vienna Convention tells us when we may look to supplementary means of interpretation, such as the preparatory works for treaties. And essentially, they can be looked at to resolve ambiguity or absurdity, or to confirm the ordinary meaning, which means that having arrived at the ordinary meaning, one can go to the sources to see if they actually generate a degree of uncertainty such that one should revise one's meaning. So in practice, courts and tribunals will often look to preparatory works where they're available. As I've said, a fundamental limit of treaty law is the pacta tertiis principle. Treaties do not bind third parties, and that becomes particularly important when we consider the statute of the International Criminal Court a treaty, and the relationship of that court to major non-parties, such as the United States. To summarise what we've said about customary international law, it's a form of unwritten law based on these two elements of consistent state practice and opinio juris, not, unfortunately, opinion juris, as appears on the slide, an autocorrect error. As I've said, it is generally binding. It binds all states in the international community, but its disadvantage compared to treaty law is that it's often, by its nature, less specific. One will wind up debating what the content of the rule is. And as we've said, it does have a role before international courts and tribunals, potentially in interpreting some elements of international law, particularly the concept of violations of the laws and customs of war. And general principles of law, as I've said, are derived from the general principles of law recognised by the world's major legal systems and can have a gap-filling role before international courts and tribunals after the role of treaty and custom have been exhausted. Particularly in international criminal law, certain concepts may be very important, such as in dubio pro reo, which is a principle of interpretation in criminal law. Where there is doubt, the rule should be benefited in a manner that, the rule should be interpreted in a manner that benefits the accused. That is, to the extent that there is any ambiguity, it should favour the defendant. And to recap on jus cogens norms and rules. So the essential idea is that these are peremptory norms, principles or rules from which no derogation is possible. As I've said, the scope of such norms, the body of rules that has jus cogens status, is to some extent controversial. And there is a tendency, particularly amongst human rights lawyers, towards over-expansive claims about both which rules have jus cogens status and what the ultimate consequences of that status might be. And as I've said, at one level one has to wonder whether, if all one says about jus cogens norms is that, for example, it is illegal to act contrary to them, do we really need to be told that about a concept like genocide or war crimes? Now, one question that arises is, if a norm, such as the rule against genocide, has jus cogens status, does that carry other rules with it? Does that mean that the crime is subject to universal jurisdiction and can be prosecuted by any court anywhere? And in many cases regarding international crimes, that will clearly be the case. The more controversial question then is, but in the case of norms contrary to jus cogens, crimes contrary to jus cogens, is there also a requirement that you either prosecute a suspect in your territory or extradite them to a state which is willing to prosecute them? And that's sometimes summed up in the Latin aut dedere, aut judicare, either prosecute or extradite. And the evidence in state practice that there is such an obligation which attaches to crimes simply because they are of jus cogens status is quite weak, but the argument is still sometimes made. All right, that's everything I wanted to cover in terms of the sources of international criminal law, and the next of these short presentations will pick up on principles of jurisdiction. Thank you for your attention.